Ladies and gentlemen, I'm going to go ahead and get us started. My name is Lisa Schultz. I am a member of the faculty here at the University of St. Thomas School of Law and co-director of the Terence J. Murphy Institute for Catholic Thought, Law, and Public Policy. I am very, very pleased and honored to welcome all of you today to this two-part program on business as an agent for social change, social entrepreneurship, benefit corporations, and curing poverty. I welcome you on behalf of all of the University of St. Thomas programs working together to co-sponsor what is truly an interdisciplinary program. The co-sponsors are all listed on the back of your program. They are the Veritas Institute, the Terence J. Murphy Institute, the John A. Ryan Institute for Catholic Social Thought, the Joseph and Edith Habiger Institute for Catholic Leadership, the Justice and Peace Studies Program, and the St. Thomas Department of Entrepreneurship. Over the past few years, businesses in the U.S. have asserted themselves as active participants in political campaigns and bearers of conscience rights. One of the most important questions raised by this development is whether this greater social power carries with it greater social responsibility. This afternoon, we're going to be looking at two developments in that debate: the social entrepreneurship movement and the emergence of what is, as of a couple of hours ago, going to be a new form of corporate organization here in Minnesota, the Benefit Corporation. We'll be guided in that exploration today by an extraordinary interdisciplinary team of experts in these topics who will look deeply into both of these developments, exploring some of the unintended consequences that complicate our assessment of both of these developments. We'll begin with some context into the social entrepreneurship movement by Professors Michael Naughton, Director of the John Ryan Institute for Catholic Social Thought, and John McVeigh, Professor of Entrepreneurship at the St. Thomas Opus College of Business. Dr. Naughton was one of the principal authors of the groundbreaking recent publication by the Pontifical Council for Justice and Peace, The Vocation of a Business Leader. Both Drs. Naughton and McVeigh bring their extensive practical experience in business backgrounds and their rich expertise in business ethics to bear on today's issues. After hearing from Drs. Naughton and McVeigh, we'll move directly into an exploration of today's topic in Minnesota, benefit corporations. Our panelists for this part of the program also bring a very rich blend of practical legal experience and some sound scholarly backgrounds into the conversation. We'll begin with a presentation by Professor Lyman Johnson, Lejeune Distinguished Chair in Law at the UST School of Law, and Robert O. Bentley Professor of Law at the Washington and Lee University in Lexington, Virginia. Professor Johnson's expertise in this area has been recognized by, among other things, election to the American Law Institute, where he currently serves as a member of the consultative group for the Principles of the Law of Nonprofit Organizations Project. Then we will have a response to Professor Johnson's presentation from Elizabeth Babson, and she will bring her perspective as a member of the Corporate and Securities Practice Group at the law firm of Drinker, Biddle, and Reith in Philadelphia. Ms. Babson has been officially designated on her webpage as a B-corp champion, and she has written extensively on the topic, contributing to the influential recent Benefit Corporation's white paper called The Need and Rationale for the Benefit Corporation: Why It Is the Legal Form That Best Addresses the Needs of Social Entrepreneurs, Investors, and Ultimately the Public. And finally, we will hear from Professor Haskell Murray, who will respond also to Professor Johnson's paper from his perspective as a professor of management at Belmont University in Nashville, Tennessee, and from his years of practice in corporate law groups at King and Spalding in Georgia and a clerkship on the Delaware Court of Chancery. That's going to leave us with some time for your questions before closing by transitioning over to the building across the street for a small reception, and for those of you who are sticking around for our evening program, a wonderful program on curing poverty. So with that, I'm going to leave you to our experts, and I'll first welcome Dr. Naughton to the stage.
Thank you, Lisa. This afternoon, we want to address this question: can business be a better agent for social change? And in particular, we want to connect this question to these two movements, social entrepreneurship and the Benefit Corporation. As a Catholic university, at St. Thomas, we find this topic of critical importance. We stand on the shoulders of a 3,000-year-old tradition and addresses this question and the social role of business within society. I will simply offer a few brief remarks on the underlying logic which I think animates this discussion of social entrepreneurship and benefit corporations. I realize that for some, that this exploration of the underlying logics may appear to be simply an academic exercise that distracts us from the practical matters at hand. But I'd like to propose that no one in this room is coming to discussion with a value-free approach, and those who think they are may take heed of the warning of John Maynard Keynes. And Keynes wrote this, an economist: "Practical men who believe themselves to be quite exempt from any intellectual influence are usually the slaves of some defunct economist." So, to address business as a social change agent, it is important that we address the good that business does. This has been expressed in the document that Lisa mentioned that we were a part of from the Pontifical Council for Justice and Peace. And it talks about the good that business does in three ways, in terms of three goods, three institutional goods of a business. First, good goods, making goods which are truly good and services which are truly served. Good work, organizing work where employees develop their gifts and talents. And good wealth, creating sustainable wealth and distributing it justly. As an institution, business contributes to the larger community by the way that it orders these three goods, which can be shared in common with customers, employees, investors, suppliers, and the larger community. We have a rather vigorous debate going on in this country about whether business is really about these goods, or is it simply about one good, namely wealth, and more specifically, namely shareholder wealth maximization. This reductionistic temptation to flatten an institution to only one good is found not only in business, but also in reducing universities to simply career credentialing or marriage to mere sentiment among partners. The significant risk of this reductionistic logic is implosion. When institutions fail to serve something outside of themselves, they are prone to suffocation. How we conceive of our institutions and the underlying logic we bring to understand these institutions will have significant consequences for future generations. So let me highlight three logics that underline often the conversation that we have when we discuss business. And the first is what I would call the logic of gift. In 2009, during the financial crisis, Pope Benedict wrote the following in an encyclical called Caritas in Veritate. And he said, "The great challenge before us is to demonstrate in thinking and behavior that in commercial relationships, the logic of gift can and must find its place within normal economic activity." What does he mean by the logic of gift? He explains actually that the logic of gift is usually first nurtured within what we call civil society, namely the family, education, religion, volunteer organizations, and other forms of civic life. And that these ought to animate the economic order, and in particular business. And at the heart of this logic is the recognition that whoever it is has been given something and they actually have something to give. We find this quite clearly in the scriptures when it says, "From everyone who has been given much, much will be demanded, and from the one who has been entrusted with much, much will be asked." And so this logic of gift confronts the business person with a fundamental vision of life, namely that they have been given great resources, and in that gift, much is expected to them. There is a dynamism between receiving and giving, receiving and giving. Now, within a market and legal system driven by competition and incentives, as well as laws and contracts, this logic of gift, when it operates, is always in tension with other logics, such as those of the market and those of the contract. And thus, there are these dominant logics. And one of the significant concerns of many people, especially in light of the most recent financial crisis, is that the logic of the market and the logic of the contract have become so dominant in economic life that they've created significant disorders. Barry Schwartz, in two very fascinating TED Talks, captures these two logics in the following way. He says that whenever leaders are facing issues, they're constantly facing problems. One is reminded of Frank Schwinn, who is the CEO of the Schwinn Bicycle, when he said, "Being in trouble and being in business are the same thing. The day you're out of trouble is the day you're out of business," right? The key issue, however, is how do you respond to the troubles? And Schwartz explains that there are two fundamental dominant logics that people are constantly, in a sense, referring back to. It's becoming, in a sense, their default system. And the first one is this idea of rule fixation and the logic of the contract. He says, when things are not going right, we have to make, in a sense, the response is that we often have to make more rules, develop more laws, sign more contracts, set up more detailed procedures to get people to do the right thing, or at least get them not to do the wrong thing. And thus we give teachers scripts, we give judges mandatory sentences, we lengthen contracts with employees, always thinking that one more rule, one more procedure is going to solve the problem. This default system of rule-making creates a proceduralism often within the ideas of leaders where they take refuge in such laws and processes, and in a sense, they can escape the importance of making a judgment. They automatically revert to the handbook, the organizational charts, the contract, again, thinking that such mechanisms will, in a sense, answer the reality that's in front of them. The second response, or the second way of how people respond to things, according to Schwartz, is that when things are not going right, we need to create incentives to get people to do the right thing. Such incentives tend to become drivers rather than simply rewards, and they often drive the spirit of good work out of people. Some have called, for example, stock options, managerial heroin, and like all addictions, incentives when they are drivers are not rewards, and they narrow reality with significant destructive long-term consequences. Let's be clear. Rules and incentives, contracts and markets are necessary for organizational life, but they can demoralize leaders and their organizations by reducing business to a mere logic of exchange, frustrating the relational capacity of what we would call an authentic logic of gift. Social entrepreneurship and the benefit corporations have the potential to express forms of commercial enterprises which actually can civilize the economy and humanize business, so long as a proper logic animates and accompanies such movements. So let me conclude with one more quote from Pope Benedict, and he says this in the same document. He says, space needs to be created within the market for economic activity carried out by subjects who freely choose to act according to principles other than those of pure profit, without sacrificing the production of economic value in the process. The logic of gift, he says, requires that shape and structure be given to those types of economic initiatives which, without rejecting profit, aim at a higher goal than the mere logic of exchange of equivalents, of profit as an end in itself. John and I, who've written a paper on this general topic of social entrepreneurship, believe that such a broader logic, a logic of gift, has the ability to order the logics of the market and the contract. Our deep hope is that these developments of social entrepreneurship, as well as the benefit corporations, can serve as a yeast of renewal for our market economy. And yet, like all movements and all good things, there are challenges of unintended consequences. And I'll now turn this over to John McVeigh, who will explore this issue of unintended consequences, especially in relationship to social entrepreneurship. Thank you.
Thank you, Mike, for framing the issue so well for us. I would like to follow Mike's lead by trying to use this as an opportunity to step back before we delve into directly how do we legislate to encourage social entrepreneurship, or how do we nurture it. Is this even the question that we ought to be asking? Is social entrepreneurship the way we should frame the issues? And I think we come to this debate, most of us, at one of two extremes. A lot of us come to this excited by the possibilities that social entrepreneurship brings, and that social entrepreneurship can perhaps be the solution to all the problems of business and justice. And then there are others on the other side of the fence who come very cognizant of all the dangers, that in fact social entrepreneurship is a very dangerous idea that might in fact overwhelm capitalism and destroy altruism, or possibly both. Hopefully we can today find that there's a middle path, that we can, the paper we have written is an attempt to say, can we have our cake and eat it? Can we actually take advantage of the attention and the energy around social entrepreneurship, while taking great care to make sure that we use that concept in a way that reinforces the good value of work and does not undermine that? So, let's turn first to the positive possibilities of social entrepreneurship. It's an exciting new field. It's launched 1,000 books. It's got all sorts of websites and institutes. Most notably, it's broadened the interest in entrepreneurship itself. We see this at the university. We start to see students in our program coming to us that we've never seen before. Students majoring in music, students majoring in social work, students majoring in engineering, who suddenly see this as a much bigger tent in which they can operate. So that's very exciting. What's really notable, and I would like to make this point at the start, is that we give some acknowledgement to the fact that it also is exciting from the broadest spectrums of our political divides in the country. The lefties love it because they see this as a way of humanizing sort of inhuman business, right? The right-wingers like it because isn't this a way to resolve our social problems with individual action without having to rely on government intervention? So sometimes we see at conventions like this, we see people at your very own table sitting around, and someone might turn to the person next to them and say, you know, I've come here because I really support social entrepreneurship because I see it a way to overthrow capitalism. And the person beside him say, that's funny because I came here, I really support social entrepreneurship because I see it a way to ward off socialism. Now, we might laugh at those extremes, but actually I want to go back to Mike's first point about a gift. That is a gift for us. Think of our political economic conversation we have today. How few issues there are that actually are attractive and positive right across the political spectrum. And I think that really explains why there is so much momentum behind this idea. That's a powerful idea, and it's something we need to preserve while rightly critiquing the idea at the edges. The first negative and danger I want to address are three real dangers. One, ghettoization. Second, rhetoric. And third, the danger of undermining the nature of work. Those are the three items we'd like to pursue. So the first is this issue of the ghettoization. We already have in business schools particular tension between one side of the curriculum, which emphasizes maximizing value, and the other side of the curriculum that may talk about how we actually create that, where that value is contributed to, and what's the moral worth of that value. Now, what we've seen over the years is a great deal of separation and division. We create divisions and subdivisions of those subdivisions within our curricula. And what we hope we try to do is remove some of the tensions and remove the paradoxes. And we can teach with certitude and comfort, finance in the finance class and ethics in the ethics class. But there are grave dangers to this ghettoization. And we lose control and we lose meaning. And when I was preparing this paper, I came across a quote from Parker Palmer, and I want to read it. It was him critiquing the academy and this very idea of subdivision and subdivision of subjects. He says, "We split paradoxes so reflexively that we do not understand the price that we pay for the habit anymore. The poles of paradox are like poles of a battery. If we hold them together, they generate the very power of life. But if we separate them and divide them, they become lifeless, worthless specters of themselves." And so there is a grave danger that the introduction of social entrepreneurship and its separation from, I don't know, what's the rump called? Real entrepreneurship? Other entrepreneurship? Creates another gap between this idea of business as finance and morality as a constraint, or between business good guys and business bad guys. Mike and I come from the perspective that a good liberal education is the most important fundamental for a business education. And liberal education demands of us more integration, less separation. It demands that we celebrate paradoxes, not that we separate them and sweep them under the carpet. So having talked about the danger of the ghettoization of these ideas, I want to talk a little bit about the rhetoric. There's a bunch of rhetorical problems I think we can deal with, but we need to think about quite carefully. First of all, the rhetorical risk of defining social entrepreneurship too narrowly. There are some in the literature who want to define it. Basically, this is about being non-profit. Now, if that's all we're doing with social entrepreneurship, I think it's sort of a waste of time. We've done this a few times. We rebranded charity as non-profit. If we rebrand it again as social entrepreneurship, that might have some spin value, but it really doesn't get at the truly interesting phenomenon, which are these new hybrid organizations, which may or may not be for-profit or may be somewhere in between. The broader definition is also just as damaging. If we allow this term to be used for any form of creative enterprise, if everybody from Mother Teresa to Yo-Yo Ma to Steve Jobs is suddenly a social entrepreneur, then the term really doesn't even have any meaning, and it's really become separated from value creation and trade. So there's some real risks we sort of sow when we're careless about how we use this term. The third issue here is there's also a problem of an implied morality. If we give this honorific term social to certain ventures, what does this mean for the other ventures? Are they asocial, antisocial? If we encourage social entrepreneurs to believe that they are the people who pursue the good in our society through value and trade, does that mean other people in positions of value and trade don't even have to think about the good anymore? So beyond the ghetto risk, beyond the risk of rhetoric, the most serious risk we believe, and what we sort of center our paper on, is this idea of what this does to how we think about work, the very value of work. Our field of social entrepreneurship has we have a surfeit of definitions, all competing and none consistent. But if you run down this list, and sorry, the font is obviously a little small, but I'll read a few for you. These are supposed to be distinctive characteristics of social entrepreneurship from the literature. Adopt a mission to create and sustain social value, not just private value. Act boldly without being limited by resources currently in hand. Paying attention to market forces without losing sight for their underlying mission. So the bunch of definitions. And I would just ask you, which of those supposedly distinctive characteristics would we not want to apply to any business owner, any entrepreneur, any business? And I think the answer is none. So in fact, if we remove these characteristics from general entrepreneurship and general work, what does that mean we're left with as a definition of work? If work is not about connecting value and your values, not about connecting the value you're creating with the needs of society, what does that mean? Work is really just about technique. Work is really just about maximizing financial resources. So how do we get out of this hole? Well, one of the things I think we need to do, first as academics, is we need to stop wasting our time trying to get finer, more precise definitions of what social entrepreneurship is and is not. It creates careers for us as academics. We can have conferences, we can have arguments, we can publish papers, but it really doesn't impact the rest of the world. The answer is we need to recognize that the reason we're struggling to truly define what is and what is not social entrepreneurship is this is a symptom of a bigger problem. It's what Freeman has called the separation thesis. Once we separate our dialogues about value creation and trade from our dialogue about morality, our definitions become unsustainable. It doesn't make sense anymore. And so what we need to do, instead of fine-tuning our definitions and arguing, we need to ask a different question. And we need to ask a specifically normative question. And the question we would propose to replace the questions like, what is social entrepreneurship? What's distinctive about social entrepreneurship? What are the unique theories of entrepreneurship? We should drop those questions and replace them with a harder question. What does it mean to be a good entrepreneur? A morally good entrepreneur? And what's the difference between good entrepreneurship and bad entrepreneurship? Now, fortunately, as Mike has pointed out, we don't have to start this from scratch. We have been able to build on Catholic social teaching, has had principles that are very much aligned to this question for a number of years. These ideas are not unique to the Catholic faith. They're shared by many religions and many cultures and non-religions around the world. But we've explicitly built on the Catholic social teaching. And as Mike has said, there are at least these three distinctive ways that entrepreneurship can contribute to the good. By creating the most obvious one, and probably the most underemphasized, by the creation of good goods and services that actually enrich our lives. Good work being the place where we form our character, where we spend most of our time, where we form our habits, and also work being the place where we form a lot of our foundational relationships within our society. And then finally, good wealth, through the creation of sustainable, fairly distributed wealth, augmented by altruism. So let me go into each of those briefly and tell you where I don't want to start, which is with altruism. Normally we talk about what makes a good entrepreneur. And we focus on altruism. A good entrepreneur is the person who gives hugely altruistically after they've closed the books and the trading is gone. And we want to change that frame and say altruism, we'll come to altruism at the end. Altruism is always important, but it's not where we should start. The biggest contribution an entrepreneur can make is the primary goods that they manufacture and the services they create. We have a speaker, a CEO, comes to our students' classes sometimes, and he's made his career manufacturing hinges, and he comes to talk about being a good entrepreneur. And he always starts saying, I feel on the back foot, I feel underwhelmed because I feel I should have spent my career working for a charity or making someone like Medtronic makes medical products that save people's lives. But I just make hinges. And how good can that be? That obviously from that conversation cannot be the right answer. The world would be a terrible place if everyone was employed working for charities and making medical devices. We need hinges, we need footwear, we need roofing products. All of those are moral goods if the good is designed into them and if they are made in appropriately moral fashion. So the questions we ought to be asking, instead of how much did the entrepreneur donate, is this product the best use of your talents? Is this product actually a good product? Is it designed to be as good as it can be? All products have unintended consequences. Have we designed out as many of the unintended consequences as possible? That is how you do good. The second aspect Mike mentioned was good work, and this is 2 dimensions. As I said, the first is, and again underemphasized really in the literature, is the role of how the role of entrepreneurship and work changes our own character. This is, from a Catholic perspective, what we call sort of the subjective dimension of work. In our class, we sort of use the metaphor of, the medieval blacksmith, a cartoon character, bashing metal away, changing the world through work, changing the shape of the metal. But doing that for days, for weeks, for decades, eventually that work changes the person who's doing it. They become this muscle-distorted version of themselves. Well, that's true for all of us. Not only do we change the world through our work, the work changes the people we become. And that becomes even more important in intellectual pursuits. How we think is influenced by how we act. How we think at work, where we spend most of our time, changes our habits, changes our character. So our character really evolves from our decisions, and our decisions emerge from our actions. And so therefore the critical question for the entrepreneur is, what sort of an entrepreneur do I want to be? Not should I be a social entrepreneur or a asocial entrepreneur, but what sort of a human being do I want to be? What do I want to stand for? And so that brings a great moral good into our society. If we have leaders who are actually acting on principle, that contributes to a greater good. If we have business leaders who are acting out of cynicism and out of distrust, then that will obviously have a negative impact on our greater good. The second element of good work is, as we said earlier, the relationships that are formed by business. And this goes back to this idea that trade is a basic part of the human condition. We tend to talk as if, the modern corporation is very new, and these are new ideas. But in fact, as long as human beings have existed, they have traded with their neighbors. And the basis for trade is trust, honesty, and a lot of that ethic that are the foundational blocks of our society is built up through these trading relationships. And so there's a great role in how we treat our employees, how we talk to our suppliers, how we treat our suppliers, that is a moral good in our society. For instance, is it really wise for an entrepreneurship professor to advise their students, to run down their accounts receivable and run up their receivables when the recession's bad? Is that wise? In terms of maximizing cash flow, it's wise, but what are the wider consequences of those relationships we're putting under strain from our suppliers and in the rest of our community? All of this, the good work, the character, the leadership, the things we've talked about at the end here, is completely independent about whether you're a non-profit, a for-profit, a social venture, a non-social venture, an asocial venture. All of these institutions have relations with their employees, relations with their customers and suppliers, and can do those well or can do those badly, and can do those in a way that reinforce the good or not the good. The legal, the tax questions are somewhat by the by. The final area that we mentioned in terms of doing good is good wealth. And as I said at the start, we don't want to start with altruism. Beyond pure altruism, the good of an entrepreneur can be measured in a number of ways with regard to wealth. And this is where it gets tricky. This is where it gets much more contentious. This is where it gets much more political. From our perspective, there are demands that, from a Catholic perspective, this makes on us as entrepreneurs in terms of the creation of wealth. For instance, good wealth requires a tricky balance between 2 important principles. The principle that the people who create the wealth have some right to be rewarded for that, and the principle that everyone has the right to a living wage. And we have to balance those tensions. We see this played out in the social sphere, in the legal sphere right now, in the political sphere, but that happens true in your own entrepreneurial business. How do you balance who's actually generating the wealth and how that's shared and that everyone is being given a living wage? Good wealth is also captured by individual action. It's seen as an individual task, but the truth is, from a Catholic perspective, nobody creates wealth de novo. All wealth is created in terms of a social contract, and all wealth has got social ties to it. And so there are unavoidable questions about wealth inequality that must be addressed in order to ask yourself the question, am I being a good entrepreneur? Finally, the creation of wealth from a Catholic perspective creates a particular responsibility and solidarity to the poor, the poorest of the poor. And again, that does then bring in back in altruism. But altruism is not always about cash handouts. It serves no one's interest for the small entrepreneurial startup that's cash hungry to make a big donation to the United Way at the end of the year and go bankrupt. There are other ways to give altruistically in terms of giving your time, your skills, your service, beyond just acknowledging that the good of an entrepreneur is the writing of a check at the end of the year. So we would like to change the question from not should it be social entrepreneurship or conventional entrepreneurship, which is better, which is righter, which is more justified, to a broader question, what does it mean to be a good entrepreneur? And some might say it's hard, and for sure it is hard to live in a world where there are three goods that are in tension that we have to balance. It's a much harder world than a world of good guys and bad guys, of goody two-shoes social entrepreneurs who never do any harm, and really evil business, ordinary entrepreneurs who are just trying to exploit the world for their own interest. We're trying to propose that that's a pretty immature way to paint the world. It is harder, but we've got to do it. In the long run, good entrepreneurship requires us to succeed in all three of those dimensions. It's a bit like a diet, I think, the metaphor. It is true that on any particular day, it is impossible for me to have a balanced diet. At any particular meal, it is impossible for me to actually have my goals of a diet. That does not mean I lose sight of the value of an ideal diet over my lifetime. And so because it's very hard to balance these three goods in the short term at any point in time, does not mean we have to give up the value of aspiring towards the ideal. So what does this change? Well, Mike and I can really only talk about how it changed us in terms of how we teach, and it did make a difference, changing this conversation from social entrepreneurship or not to a question of what does it mean to be a good entrepreneur. We now teach classes in undergraduate in social entrepreneurship. We've developed a new class on faith, career, and entrepreneurship. This paper on the three goods of entrepreneurship is the philosophical backbone to that course. We use a lot of experiential learning in a theology course about business, about case studies. We have few lectures, we do some theological readings, we develop our own cases, and we encourage our students, in fact require our students, to present their entrepreneurial dreams and to write a "this I believe" statement as part of the course, so that there is an explicit personal normative basis to the conversation about how are you going to go out there and create value and trade. I will end with someone who's not from the center of our political discourse, Hayek, who had a warning for us, and I think this will be a segue to our conversation about how do we legislate given some of these unintended consequences and difficulties. And I believe this was from when he was receiving his Nobel Prize. He did this speech called The Pretense of Knowledge. And he gives us a caution, which I think is wise. He says, if a man is not to do more harm than good in his efforts to improve the social order, he will have to learn that he cannot acquire the full knowledge which would make mastery of events possible. He will therefore have to use what knowledge he can achieve, not to shape the results as a craftsman shapes his handiwork, but rather to cultivate the growth provided by the appropriate environment in the manner in which a gardener does for his plants. The recognition that the insuperable limits of knowledge ought to indeed teach the student of society a lesson of humility, which should guard him against being an accomplice in man's fatal striving to control society. Social enterprise is an emerging field which needs to be carefully nurtured with humility, with experimentation as it merges, in a way that protects the belief that all work should be good work. All work should build character and community. All work should contribute to the greater good. And we hope we can do that in a way that preserves the excitement around social entrepreneurship and does not threaten our broader understanding about what the whole of work actually means. Thank you.
Well, thank you to all of you for coming today. I'm going to turn the conversation in a somewhat different direction. I hope it's one that is complementary to that which was articulated by Mike and John, but I'm going to try to offer a corporate law perspective on social entrepreneurship and benefit corporations. And as Lisa mentioned, I was going to say something about the law in Minnesota that was about to be passed into law, but that law, apparently subject to Governor Dayton's signature, has now been passed through the legislature. I want to briefly summarize my main points, simply because these main points form the framework of several other issues that I'm going to touch on. First, there continues to be a great deal of misunderstanding about what the law does and does not demand of business corporations. Specifically, there is no law in the United States that requires a corporation to maximize profits or maximize shareholder wealth. Instead, the law is largely agnostic on the corporation's objectives. Second, the corporation is and always has been a very valuable vehicle for simultaneously pursuing profits, although not necessarily maximizing them, while also serving one or more other worthy but non-pecuniary goals. Third, the benefit corporation is a new type of for-profit business corporation, soon to be available in Minnesota, I believe effective January 1, that is specifically designed to facilitate these mixed-purpose businesses that seek to make profits, although not necessarily maximizing profits, while also providing one or more social benefits. These types of corporations are brand new. We have very little legal or business experience with them. They afford certain decided advantages to socially minded entrepreneurs, but they are hobbled by certain design flaws and uncertainties. They should be used advisedly and carefully, particularly by prospective minority investors. Over time, the reception given to these companies by investors and consumers will determine their success. And we can expect further legal refinements to improve these forms of business, but the market reception to and development of sound business norms and practices is likely to play a far larger role than law itself in what these new companies look like. I want to step back very briefly in time, because I think it's easier to understand where we are legally if we look back a couple of hundred years. In the year 1800, there were a mere 335 business corporations in this country. That's a poor day's work for the Delaware Secretary of State today. Undoubtedly, they form hundreds of corporations every day. These corporations were chartered by special legislative grant, and they largely were formed to advance some public purpose. Perhaps build a roadway, a canal, a turnpike, something that had a public dimension to it. Now, later during the mid and late 19th century industrialization period, corporations were permitted to pursue profits and only pursue profits. But they were never legally required to do that. And that's a distinction that people typically fail to make. You're permitted to pursue profits, you're permitted to maximize profits, but you're not required to do that. Today, it remains the case that corporations do not have to maximize profits. There is no statute that says this. In fact, statutes in over 30 states, including Minnesota, state very explicitly that boards of directors can consider a number of stakeholders, which include, but are not limited to, equity investors. If that's the case, then what is the source of this widely held view that business corporations must be money maximizers. I think it stems, first of all, from long-standing business lore. Deeply embedded customs and practices within the business community itself, including the way that executive compensation is designed. It stems from market pressures from shareholders, a growing concern with rising investor activism, where it's not just hedge funds, but traditional institutional investors are increasingly putting pressure on management to maximize for the short term. But I think it also stems from a failure to rightly teach this subject in our law schools and business schools. A point that was made very tellingly by the Brookings Institute in a 2011 study that surveyed how exactly is the corporate objective taught in our leading business and law schools. Second, I think the faulty belief also stems from a mere handful of judicial decisions, including one from Delaware involving Craigslist and eBay from 2010. And I'm not going to take students who are here through the Craigslist case, but let me briefly tell you about Craigslist. I think we all know who Craigslist is. It's the leading online classified ad provider. It was organized as a California corporation that subsequently reincorporated in Delaware. They are avowedly a community service business. They have a social mission. They do not charge for most of their advertising. They charge for apartment listings in New York City and job postings in selected cities. The founders have always said they are not about making a lot of money. One of the three founders wanted to get out, and through a long series of events, eBay came to own 28% of Craigslist. Now, eBay immediately wanted to monetize Craigslist. They wanted to build this platform and really run with it. The two founders did not want to do that. They had made it very clear to eBay, we don't want to monetize this model. Complicated legal maneuvers, they go to court. Essentially, the legal claim was over an anti-takeover provision that the founders put into place. The chancellor struck down that anti-takeover provision. In doing so, he used very, very strong language about what he thought the purpose of a business corporation was in the United States. But he did not change Craigslist's business strategy. That judge did not change how Craigslist runs business. It still may and does operate as a social mission. Now, benefit corporations are in large measure a response to eBay. They are a disavowal of eBay. They started in Maryland in 2010. They're now the law in about 22 or 23 states. They've been proposed in a number of others. And at their most general level, they do three things. First, they explicitly reject the idea that a business corporation must maximize profits, and instead they advance the idea that for-profit corporations may, they don't have to, but they can, seek both profits and other non-pecuniary goals. That is a fundamental element of benefit corporations. Second, they provide a ready-made, off-the-shelf business entity ready for entrepreneurs to pursue their own unique blend of profit-seeking and non-monetary goals. Like the rise of craft breweries aimed at creating unique beers, you might say that benefit corporation statutes are designed to facilitate the rise of specially crafted, socially oriented business. It simply provides you with a statutory framework for doing that. Third, although these statutes do not do this expressly, they implicitly acknowledge that key actors in the business sphere are not simply homo economicus. They are not simply economic and financial in nature. They are social, relational, charitable, self-sacrificing, and for many, motivated by religious and spiritual convictions, even as they try to navigate their way in the business world. In short, they try to accommodate, I think, the more humane and realistic anthropological understanding of the human business actor that Mike and John advocate. They also seek to enrich the concept of institutional pluralism within the corporate sphere. They renounce the simplistic view that there are only two types of corporations: purely charitable or purely money maximizers. In short, they reject the idea that there is a corporate biculture: nonprofit, profit maximizers. Within the profit sphere, they reject the idea that there is a monoculture, that if you're a for-profit business corporation, you must maximize profits. Instead, they embody the belief that we can have a rich, diverse business ecology in which corporate founders and managers can position their company at any point along a spectrum. For some, you can think hedge funds here, other investment pool managers, they're going to maximize profits. The other end of the spectrum, purely charitable endeavors. But the key point here is that you might position your company at any point in between those extremes, where you seek to combine the pursuit of profits with other worthy goals. Now, let me hone in a little bit on benefit corporations. I'm going to identify key features, and I'm going to point out what I think are key flaws. And I'll offer a little bit of practical advice and try to peer into the future, which is always a dangerous activity, but I will try. I'm going to focus on the expected, or I shouldn't say expected, I should say new Minnesota statute. First, some key features. Benefit corporation statutes are built on the regular for-profit corporate statute platform. It is not a wholly new creation. They are built on the corporate statute platform, except where specifically noted. These are business corporations. Second, investors do not get a tax deduction the way they would with a charity, but at the same time they can receive distributions, which is not the case with a charity. Third, when you bring in investors, you are selling securities. People who are used to fundraising in the charitable realm have to be aware when you're selling interests in these benefit corporations, you are engaged in the offer and sale of a security. Minnesota is going to permit two types of public benefit corporations, and here the terminology can get a little confusing, so I'm going to try to keep it as clear as I can. The first type is called a general benefit corporation. General benefit corporation. This is a kind of public benefit corporation that elects to pursue only a general public benefit or a general public benefit and one or more specific public benefits. And I will define those two terms shortly because they're critical. The second type of public benefit corporation is a specific benefit corporation. This is a public benefit corporation that must identify in its articles a specific public benefit that it will pursue. Now, two types then: public benefit corporation, under that a general benefit corporation, and a specific benefit corporation. What is a general public benefit? A net material positive impact on society, the environment, and the well-being of present and future generations. That is, a general benefit corporation has to have a threefold impact on society, on the environment, and on present and future generations. Now, that is a very tall order in my view. But remember, these companies only need to pursue general benefits. They don't need to actually attain them. It's a critical point. You must pursue these not necessarily attain them. It's my guess that these type of corporations will be fairly rare. The second type of public benefit corporation is a specific public benefit corporation, and specific public benefit is defined very broadly. One or more positive impacts or reduction of negative impacts on specified categories of natural persons, entities, communities, or interests other than shareholders as shareholders. Now, whether intended or not, these constraints are so loose that many such public benefit businesses may not be all that socially responsible and may be formed to pursue what many may regard as largely private benefits. An example, it strikes me that a specific benefit corporation could be formed in Minnesota for the purpose of advancing the interests of the top 1% of income earners. Whether that was the intent or not, it's a very broad category, and there may be no social to that entrepreneurship. Delaware, by contrast, seeks to rein in a little bit the kinds of companies that are formed by limiting the effects, not limiting, but reciting the effects of artistic, charitable, cultural, educational, environmental, literary, medical, religious, scientific nature. Trying to sort of spotlight business people on these more social endeavors. Whatever one thinks of Minnesota's definitions here, I actually do applaud Minnesota for the concept of a specific benefit corporation and not just going with a general benefit. I think this potentially could be a game changer. A feature of this statute is that to move from a traditional business corporation into a benefit corporation, you need quite a high vote. 2/3 of the shareholders must vote to elect this status. If you are a benefit corporation and wish to terminate that status, 2/3 of the shareholders must vote to terminate that status. As I read the statute, this means all shares, not just voting shares. In each of these situations, a shareholder may dissent. And by dissenting, they can seek cash, get cashed out, and leave. So if somebody in a traditional business corporation that elects to become a benefit corporation doesn't like that change, they can seek fair value and get cashed out. One challenge I see here is valuation itself, because you're not valuing a traditional business corporation that's going to generate an income stream that is known. Because of this non-pecuniary benefit that's being sought, it seems to me traditional valuation models might need to be adjusted to come up with what fair value is. Also, under the Minnesota statute, once you are a public benefit corporation, you can add or drop specific benefits. For example, if you're formed to pursue purposes A and B, and that's in your articles, you can drop B or add C, and there's no right to dissent. You could dramatically change the direction of the business, and there would be no shareholder right to dissent. Now, let me just highlight a few concerns here. Let me start with accountability. Holding directors and officers accountable for their conduct is a perennial problem in corporate law. But I think it will be especially challenging in benefit corporations. The irony is that precisely because benefit corporations permit the pursuit of non-pecuniary goals, boards of directors will have more excuses for failing to achieve either those goals or the profit-making goal. If they fall down on one objective, they can simply say that they were emphasizing the other one. I think this is an inherent structural feature of mixed-purpose businesses governed by a board of directors that is granted broad discretion. I'm not sure exactly how to counter that. It's the nature of the beast. The chief mechanisms of accountability in the Minnesota statute are these: the annual report. And a lot could be said here, but I'll be very brief. It's a disclose and explain document, with termination being the sanction for not filing it. It's a single sanction penalty. File it, or you no longer exist. So I think the idea is if you make the sanction stiff enough, people will actually file these things. The report has to describe the ways in which and the extent to which the identified benefits were pursued and created. I think it should be prepared with great care by boards of directors. I think it should be read with equally great care by investors and other interested parties. Voting in a public benefit corporation is still only done by shareholders. Stakeholders or targeted beneficiaries have no say in the governance of the corporation. Shareholders and shareholders alone control the board of directors. Fiduciary duties, a customary constraint on directors and officers, will, in my opinion, be very weak constraints in benefit corporations for several reasons. As a matter of theory, the identity of the person to whom a director's duty is owed should align with the content of the duty. Again, the identity of the person to whom a duty is owed should align with the content of the duty. But with general benefit corporations, that's not the case. Directors of general benefit corporations must consider various stakeholders, but they do not owe any duty to them. This is a basic design flaw, and I think it reflects the way in which these statutes are a sort of confused stew of stakeholderism mixed with the pursuit of the larger public benefit. The director duty, in my view, should be quite simply to do this: act in good faith to pursue the best interests of the corporation. That is, to pursue the public benefit and to pursue shareholder wealth. Very simple focus. Directors of specific benefit corporations have a far more focused and better articulated standard. They are to consider only the interest of shareholders and the company's ability to pursue its specific benefit purpose. Far better, but even here, directors need only consider these interests, not necessarily achieve particular outcomes. I think directors are going to have to work all of this out for themselves as to what this means. I do think, in anticipation of litigation, boards of directors and lawyers who counsel them need to be very careful in constructing the minutes of meetings to make sure you say the magic words, but also have the underlying reality that boards of directors did consider the appropriate considerations. A director who does that very little bit has a safe harbor from liability. Very good for the director, maybe not so good for accountability. Moreover, the Articles of Incorporation of a Minnesota Public Benefit Corporation can provide that failure to even do that little bit, in other words, to utterly abdicate the director duty or to veer away from the very purpose of the corporation, if done by a disinterested director, will not be considered a breach of the duty of loyalty. I find that, as a corporate law scholar, to be a very radical provision. To absolve ex ante directors from breaching a duty of loyalty, even if they totally abdicate the pursuit of the stated purpose of the corporation. Relatedly, the corporation itself is not liable for money damages if it fails to even pursue the public benefit. Strikes me as quite odd. There are other remedies, but you don't necessarily sue to get your money back. I think the failure to address the responsibilities of officers is a puzzling feature. If I were counseling boards of directors, I would align very carefully what I expected out of senior officers so that it's synced up with what the director's own duties are. There should be a real synchronization of the duties that directors are held to and what they expect from their senior officers. sort of build on Mike and John's point. Nothing in these benefit corporation statutes should be construed to prohibit regular business corporations from inserting mixed purposes in their articles and engaging in social entrepreneurship as traditional corporations. It would be unfortunate and deeply ironic if, as a result of a new business form designed to grow social entrepreneurship, that these statutes might actually be thought to legally preclude or even slow down traditional business corporations from doing the sorts of things that Mike and John talked about. Just one example is the Hobby Lobby and Conestoga Wood corporations that now have a case in the Supreme Court. They are organized, in Hobby Lobby's case, as a traditional Oklahoma business corporation. Conestoga Wood Specialties is organized as a regular, for-profit Pennsylvania business corporation. They avowedly are trying to blend the seeking of profits with their religious mission. It would be ironic if people said that now, with the rise of benefit corporations, that is inappropriate behavior. Now, a word of advice for prospective minority investors. My advice, act like a creditor or a preferred shareholder. Again, if you're contemplating becoming a minority investor, act like a creditor or a preferred shareholder. By this I mean, do not simply become a shareholder, but enter into a contractual relationship where rights and duties are clearly spelled out and you seek protections beyond the corporate statute. Think very carefully about your benchmarks for performance and your expected exit strategy, negotiating some kind of put option or some other way that you can exit the venture. Finally, given the legal green light that benefit corporations will have to pursue mixed purposes, they now must succeed or fail in the marketplace. Unknowns to me are whether investors will actually invest in these businesses and whether consumers will actually support them. If they actually do and not just say they do, then I worry that people don't necessarily spend their money the way they say they will. If they do, then I think norms and practices within these corporations will evolve in a way that will be far more significant for the future of these companies than what a business corporation statute in Minnesota or anyone else may say. In the meantime, however, I say proceed with caution under these very promising but still flawed new statutes. Thank you.
Okay. Thought that might happen. Hi, guys. My name's Lizzie Babson. My slides are in process right now, so I'll just get started without them. I'm going to give you a little bit of background, just in full disclosure, on why I'm here and what my involvement is. I work for a law firm called Drinker, Biddle, and Reith that's based in Philadelphia, Pennsylvania. We represent B-Lab, which is the nonprofit organization that is championing the legislation. Our law firm has drafted the model legislation that the numerous states, 24 now, have adopted. And in the drafting process, we were involved really from the inception, sort of taking the idea from the guys at B-Lab saying, hey, we think there's an issue in corporate law, and trying to figure out what the issues were, So trying to figure out what the issues were, what we thought the issues were, and how we could resolve them with some new legislation. So you've heard a little bit of background. I threw this slide up here just to sort of run through what we think the three key points of the legislation are. They, from my perspective, really deal with purpose, accountability, and transparency. And the states that have adopted benefit corporation legislation vary a little bit from state to state, but all the statutes that have been passed and adopted have these main characteristics. So here's the context. This was something that the guys at B-Lab were looking at as entrepreneurs themselves, and they said, you know, we've got these conscious consumers out there. There's a huge market, both on the consumer side, but also the investor side. There are people who want to make investments in companies that are doing good things for the community. The problem, as they saw it, is that corporate law was really not sufficient to foster these types of companies and to allow them to grow. So to start out, but then also to bring in outside capital from investors. And when you bring in that outside capital, to still maintain your mission over time. And if you sell your company, to make sure that the people who buy it are going to keep in place the values and the mission that you had as the founder, or that the group of people as the founders had. There really wasn't a great way to do that in the way current corporate law was. The other thing that I think everyone, probably this resonates with you, is that it's really hard to tell these days what's a good company and who just has good marketing, right? There's a lot of companies out there that claim to be doing good things, and maybe they are doing some good things, but you know, maybe in addition to donating some money to a charity, they're also polluting the lake behind their factory. And that's something that I think consumers struggle with, because there are a lot of checks and balances in place for shareholders to sort of understand how is a company performing financially. You can look at their financial statements. As a shareholder, you're entitled to get reports about how the company is doing on financial metrics. But there's really no way to measure or to test what the company is telling you with how they're doing on their social and environmental performance, how they're treating their employees, things like that. So what they saw and what we helped them with was really trying to take the situation we have now, where there's a really wide range of companies, and some of them are doing great things and some of them are doing some not so great things. And how do we sort of get a corporate form that will allow these companies that want to operate in a certain way, sort of on this triple bottom line principle, and give them the framework to do it, and to be successful, to take a company and be able to grow it over time, and maintain the values and the mission of the company. So just a little bit more background on B-Lab itself. It was founded by three guys who went to college together, and before they started B-Lab, they had a company called And1, which I don't know, some of you may be familiar with it. In the 90s, it was a pretty big basketball apparel company. They had great viral marketing and grew the company from a startup to a company that was eventually sold for over $100 million. So my law firm represented that company. These three guys, we sort of helped them grow through bringing in outside capital, fundraising, getting financing, dealing with lenders, and eventually helped them sell their company. And these guys were the total embodiment of social entrepreneurs, if you want to use that term, right? They had great programs in place for their employees. Everyone was, sorry, talking too loud. So everyone was, you know, treated really well. They had a lot of great programs in place. I would say this is a company that you would really aspire to follow the form of their model. And when they sold their company, let's just say things changed. And coming out of that experience, they decided to found B-Lab. Now, B-Lab does three main things. They certify companies, so they have a certification process. They also work on the legislation, which is what I'm doing, and then they also have this GEARS impact assessment, which is for investing, asset class investing. So those are their three main areas. We now represent B-Lab on a pro bono basis, helping them with the legislation. The next thing I'm going to talk about basically is the difference between B Corps and benefit corporations, because these are two terms that are out there that are often used interchangeably, and I think there's some confusion about it. This comes back to what does B-Lab do? So the first thing they did, and one of probably their main function, is actually to certify companies. So they have created a test that's called the B Impact Assessment that is a survey companies can take, and they answer questions over a broad range of their business. So the questions ask them, how do they treat their employees? Where do your employees live? Are they from low-income communities? What sort of wages do you pay your employees? How much is the delta between your lowest paid employee and your highest paid employee? Who are your suppliers? What protections do you have in place to make sure that they're dealing fairly with people? What's your impact on the environment? So basically, this test measures how the business is doing as a whole, right? It's not just like a LEED certification that's looking at just your environmental impact, or certified organic, which is looking at a particular product. This is a certification, almost like the Good Housekeeping seal of approval, that looks at the entire business. So if a company takes that test and gets a certain score, the test ranks the company on a scale of 0 to 200. If you get a score of 80 and you pay money to B-Lab, you can get a certification. They will give you a stamp of approval. You get that little certified B that you can put on your company website, and that entitles you to say, I passed that test. They have very stringent standards, and in my opinion, this is a great measure for people to look at to say, is this company a good company? Can I trust their marketing? Does it, match up with what they're saying? If you see this, I think that's a good measure of that. A benefit corporation, as we've been talking about, is just a legal form. So a company does not need to be certified to go to the Secretary of State and file their paperwork to become a benefit corporation. There are certain things built into the legislation that hopefully will provide mechanisms to make sure that benefit corporations are being transparent about what they're doing and that they're pursuing certain goals to hopefully be a better company. But this is not a seal of approval. If you, sign up under this legislation, that's not the same thing as being certified. So there are companies that are certified B Corps. There are companies that are just benefit corporations, the legal form, and then there also are companies that are both. They switched under the legislation and they also are certified. So I'm going to skip this because I think the history you got a little bit, but I like this slide. I think this is where we hope capitalism is going, to sort of have this broader, more enlightened view that I think you guys were talking about earlier. And I will skip through. I think you got a little bit of the history of corporations. Here we go. So this notion, and you heard Lyman talking about a little bit earlier, of shareholder primacy and wealth maximization. This is a really old case, and it's one that's often cited, and he's right when he says there's not a ton of case law that's explicit on this point about what the goal of a corporation is. But I think that's a pretty powerful statement, and it is in case law. And I think this captures generally a prevailing view that many people hold. So Milton Friedman said, there is one and only one social responsibility of business: to use its resources and engage in activities designed to increase its profits so long as it stays within the rules of the game. I think there's a lot of people that really ascribe to that sort of view of what a corporation is and how it should be acting. So from my perspective, whether it's by law, case law that's out there, what judges are saying and how they're acting, or if it's custom, economists or just commonly held beliefs, there is a constraint under regular, corporate theory to how companies are acting. And it definitely, I think you can see in the way that companies do act, affects corporate behavior. So this was something that we thought needed to be addressed, and that was why we came up with the legislation to sort of take the shareholder primacy basis and come up with an alternative and come up with a framework that looks familiar because it's a corporation, it's a for-profit business form, but it's a little bit different. I'm not going to talk again about the eBay case, but this was, as you heard, one of the things that prompted us to draft the legislation. So this is where we hope we're going, to sort of this age of sustainability. I think the benefit corporation is the way to get there. I'm going to skip over this stuff as well because that's a whole lot of corporate law, and get back to some of the specifics of the actual benefit corporation legislation. And I'm going to talk more generally than just the Minnesota legislation because that just passed today. But there's a lot of options, and a lot of companies, no matter what state you're in, you have the choice to incorporate where you want. So this is basically what I'm going to talk about is keyed towards the model legislation, which is very similar to Minnesota's, but a little bit different. One of the key things that I think differentiates benefit corporation legislation is this concept of purpose. And why I think, and I probably differ from Lyman a little bit here, I think the general public benefit purpose is one of the most important parts of the legislation. Because what this says is this company has to, as a whole, have a purpose of having a material positive impact on society and the environment. And that means you need to, in everything you do, have a positive impact. So you can't selectively say, well, my purpose is going to be to, for example, if you're Warby Parker, my purpose is to give one pair of glasses away for every pair that I sell. But then, you don't pay your employees a living wage. In a benefit corporation, you're really supposed to be taking a holistic view, and I think that's what the general public benefit purpose does, is it requires the company to have that purpose that's more broad than just one thing. Because I think most companies can probably pick one thing as a specific purpose and achieve that, whether it be, donating some money to charity and then pat themselves on the back. But if you're, not treating your employees well, or if the factories that you use to make your products are using child labor, I mean, those are things that you need to be thinking about. And that's one of the reasons we have this concept in the legislation. The model does allow you to also name a specific public benefit to sort of get at that. If you have something you want to focus on, that's going to be part of your company's mission, like the Warby Parker, put that in there, go ahead. But I think the purpose in my mind of having the general public benefit is really to make sure that the company is, as a whole, a good actor. The accountability piece, I think, is another really important piece of the legislation. And benefit corporations are accountable in a few ways. The most important, I think, is the annual benefit report, and also the requirement that that report be prepared in connection with a third-party standard. So it's not just me saying, my business is great, I donated to charity, look how good we're doing. You need to take a third-party standard. B-Lab offers one for free. It's the same one that companies use to get certified, but you can also not be certified, just take their test and sort of see how you're doing across all those measures. And then you're supposed to report on that so people can see what you're doing and measure it. And this is really to combat what I was talking about earlier, that problem of greenwashing, where you can't tell if a company is, doing one thing but saying one thing but doing another. The other thing is that shareholders and directors of a benefit corporation have the ability to enforce the mission of the company. So a shareholder who, notices that the company is, say not, or is polluting, or it doesn't even have to be a violation of law, but they're doing something that's sort of contrary to this, the mission of the company, they have the ability to take them to court and say, you need to be held accountable to your mission. And that's giving teeth and claws sort of to the concept of actually having a mission-driven company. And for investors, a lot of people talk about impact investing, and that's a really hot topic, and a lot of people want to make sure they're putting their money in a good spot. This is the mechanism that allows investors to know that if they put their money in a benefit corporation, they can do more than just sort of complain. They can actually bring a cause of action to make sure that the company they invested in stays true to, its mission and its values, and they have a way to enforce that. So that's a really key piece in my mind, because right now I think a lot of these impact investors sort of, they want to put their money somewhere good, but they can't figure out where or how, or if they do, how do they measure how that company is doing? And the benefit corporation provides a framework for that. And the transparency piece also goes back to the benefit report. Again, you have to make that available to your shareholders. So the same way investors usually get financial statements, now they're getting a report on social and environmental performance as well. So it's just another tool in their toolbook to make sure the company is doing what it says. I'll skip through these because I went through most of that. Okay, so I'm just gonna, this is sort of where we are, although I did not update this slide as of today. So we're up to 24 states now. We've got some of the big ones. New York, California, Delaware certainly was a key state to get because so many businesses are there. And especially a lot of the types of businesses that are going to be bringing in outside capital and trying to grow that often face the issue of maintaining the mission of their company over time. It's amazing how much support there has been for the legislation, and you guys touched on this. It really resonates across the aisle. So from state to state, it's interesting. We've had Republican sponsors, we've had Democratic sponsors, and it doesn't really matter. Aside from a few states, it's been really generally very positively received. And you can see we've had 23 unanimous votes, 91% approval on all floor votes. So it has been amazing going through the process how much support this has. It really appeals to everyone for various reasons. Some of the key reasons I think it's been successful is that it's voluntary, right? We're not saying everybody has to do this. There's no regulations that go along with it, so it's not a real, aside from the benefit report and having to file that, there are not a lot of proactive requirements for these companies. It sort of allows business owners and entrepreneurs to go out and run their business the same way that they would if they were set up as a regular corporation. Let me skip on here. Here's our map, which is looking pretty good, I think. And I think just to sort of wrap it up, I want to talk about a couple of the companies that have actually done this and what does it mean in practice to be a benefit corporation. So one of the most famous ones is Patagonia, and their founder is a pretty famous social activist himself, Yvon Chouinard. And he was there on the effective day in California when that law passed. This is a company that is sort of the epitome of a good company, right? They give 1% of their profits to the planet. They're very keyed into where are their materials coming from, what's their supply chain look like, how are they treating their consumers and their employees. So they're a great company that is really living what they're preaching. And for them, this statute is something that allowed them to just sort of ingrain that mission in the company. So right now, Patagonia is a privately held company. This guy, Yvon, is pretty old. I don't know what's going to happen to the company, but I do know that their mission and their purpose, their general public benefit purpose, is baked into their legal documents. So if the next person that comes in wants to change that, they can do it, but it's going to take a conscious decision. It's going to take a 2/3 vote, and it's going to, they're going to have to buy out the shares of the people who don't agree. So it really allows them to maintain their mission as they go forward. Here's a couple other ones. Another famous one is Greyston Bakery. They're based out of New York. They make the brownies for Ben and Jerry's ice cream that goes in their Chunky Monkey or whatever else. They have an open hiring policy. So all of their employees are, ex-cons who couldn't get jobs elsewhere, or a lot of the low-income community that has a hard time getting jobs. They do great stuff in the community, but they also make a lot of money, which they then give to the nonprofit organization that owns them. And these are sort of two big famous ones. There's a whole lot of little companies like the Big Bad Wolf, which only has 10 employees, that sort of have been operating this way, and they probably don't have too many shareholders. They're the small companies, but this is important to them, and what happens to their company when they sell it, or when their kids take over, that matters to them too. They want to make sure the mission is in there. And here's another company. You can sort of see, I think what I'm trying to show with these examples is that these companies that are doing it are for-profit companies that are really, they're businesses, and that's how they want to operate. And this model, I think, is a way to allow them to bake in the goodness, but not necessarily because they want to give money to charity or do one specific thing. They want to operate as a good company overall, and they want to make sure that they can stay that way. So I think that's the value of the legislation. I think it's really exciting that you guys just passed this statute, and I'm happy to answer any questions. When I'm done, I'm going to hand it over here.
UST. Yeah. You got it? You see it where it is? Just find it. It's there. Yeah, it's right here. I put it up there. Right here. Okay. Slideshow. All right, I got it. Okay.
All right, great. So thanks for sticking with us, and really honored to be on this group of panelists. Really an impressive group, and hope you enjoyed their presentations as much as I did. And thanks to St. Thomas, obviously, for having us. Beautiful school, and my first trip to Minnesota, so glad to be here. So I'm also going to talk about social enterprise law. I've been a professor. This is my 4th year. Believe it or not, it seems like it's gone by really quickly as teaching full-time, and before that I was a corporate lawyer, but I've spent most of those 4 years looking into social enterprise law in my research. I'm getting ready to publish my 4th article on social enterprise law, but I've tried to also be involved as Lizzie is in the actual process, and have advised or been part of committees in 5 states that have passed social enterprise law. And generally, when I'm in a group of business people, I'm the downer. I'm the one pointing out all the flaws in social enterprise law. And when I'm in a group of academics, I'm the cheerleader. So I fall somewhere in the middle in terms of social enterprise law. I'm a big proponent of social business generally, but I think we still have a long way to go from the legal standpoint. So the first thing I want to do, and we've been talking a lot about social enterprise and social entrepreneurship, I do want to try to define, or at least talk a little bit about what people mean when they talk about social enterprise. And those two terms, the terminology in this field, there's quite a bit of it. People actually mean different things when they talk about social entrepreneurship and when they talk about social enterprise, generally. Some people use those two terms interchangeably. Really, social entrepreneurship was the earlier term, has been talked about in business schools for probably 20, 30 years at least. Gregory Dees at Duke was one of the real leaders in talking about social entrepreneurship, and he was really mainly talking about nonprofits that started to use entrepreneurial, commercial, market-based strategies in their operation of nonprofits. That term has started to change, and especially when we talk about social enterprise in the legal context, it has gotten to be a very broad term, and people mean different things when they say social enterprise. So as Lizzie mentioned, Patagonia, one of my favorite companies, really an amazing company in a lot of respects. They probably wouldn't be categorized as social entrepreneurship, just because when most people talk about social entrepreneurship, they talk about this third category that I have up there, a justice-based enterprise that is filling a hole that the market wouldn't otherwise fill. They're generally having products that directly impact disadvantaged people, companies that, for example, Grayston Bakery would be an example that she mentioned, that focus on people who are otherwise not employable, or companies that look for ways to drill wells in Africa where the market has not come alongside. So that's the more narrow social entrepreneurship version. The term social enterprise, though, has come to incorporate both the generous companies that just give away, engage in corporate philanthropy, as we talked about. Some people just call businesses that are generous social enterprises. So Patagonia gives 1% of its revenue away to the planet, the 1% for the planet. That's a generous enterprise. Tom's Shoes may give, one shoe for every pair sold. That would perhaps fall in some people's definition of social enterprise. And then the other piece is responsible companies that that's really more of an internal focus. Are you treating your employees well? Are you manufacturing the goods that you manufacture in a responsible, sustainable way? And some people have said, really when we use social enterprise that way, we're just talking about corporate social responsibility and new clothes. And the term social enterprise, in my view, has become so broad as to almost become meaningless. Social enterprise has become an extremely broad term. Not that there's anything wrong with breweries or law firms, but there are now breweries and law firms that are dubbed social enterprises just because they act in a responsible fashion. Again, I think we should encourage that. We should encourage good entrepreneurship, but it's become an extremely broad term for us to use going forward. And I think because of this, some people have started to use different terms. We heard good entrepreneurship. Stanford has kind of gone away from the term social enterprise and chosen social innovation when they're talking about a lot of the same things. Muhammad Yunus, who founded Grameen Bank with the microcredit, kind of a famous social entrepreneur, he said he doesn't like the term social enterprise because it's too close to profit making. It's gotten kind of sullied. He uses the term social business instead. So the terminology continues. I won't spend too much time on the legal debate because you've heard some of this going forward. And again, I might fall somewhere between Professor Johnson and Ms. Babson in my understanding of corporate law. But there's been a debate going back at least to the 1930s, probably beyond that, about what is the purpose of corporation, to whom are the fiduciary duties of the directors owed, and what should be the priority of business, right? And those three questions are kind of interrelated. Professors Burley and Dodd went back and forth on that issue in the early 1930s in the Harvard Law Review. We still haven't solved that question about corporate purpose, I don't think. And Professor Johnson is right. The case law is very, very thin. Most of the lawyers and law students in the room have probably read Dodge v. Ford. There's a reason that they include a 100-year-old case in the case book. It's because there's not many other recent cases that stand for the same proposition. eBay being a more recent example. We also have in the M&A context, which is its own sort of analysis, if you will, in Delaware, the Revlon case, which you may have heard of, which says when it becomes inevitable that you're going to sell the company, then you need to consider shareholder value as a very high importance. Professor Johnson has a recent article on SSRN about the dwindling importance of Revlon that I highly recommend. And then Ben & Jerry's is sometimes trotted out as the example of these people wanted to be social entrepreneurs and corporate law forced them to sell out to Unilever. I think that's just not true. They may have been overly cautious, but Vermont, like 32 or 33 other states, has a constituency statute. There were a number of things they could have done to prevent from selling out. A couple of professors at Indiana University, Professors Page and Katz, have a really good article, I think it's in the Vermont Law Review, about Ben & Jerry's and how corporate law did not really force them to sell out. But as Professor Johnson mentioned, there is this widely held perception, at the very least, that we have to maximize shareholder value. And even among studied corporate lawyers and corporate legal academics, there's this thought that even if we don't have to maximize shareholder value, and I would agree with Professor Johnson that corporate law, at least outside the M&A context, does not require us to maximize shareholder value, I do think it does require a priority on shareholder value. At some point, you have to make the argument that it redounds to the benefit of your shareholders. That might be 100 years from now, and you can make an argument. Henry Ford could have gotten on the stand and said, the reason we're paying our employees more is because it'll reduce turnover. The reason that we're charging less is because it's going to increase our market share. The reason that we're investing in R&D is because it's going to lead to greater products, and the court would have left him alone. Same thing in eBay. In the eBay case, had the founders of Craigslist got on the stand and said, look, the reason that we don't have ads on our website is because long-term, we have a strategy to build customer will and monetize it at some point. I think corporate law, even in Delaware, would have left them alone. One of the good things about benefit corporation statutes, I think, is that it knocks down the norm of shareholder wealth focus, if you will. Maybe not maximization, but it takes the focus and puts it on the corporation as a whole and other constituents. It allows founders to be honest about their purpose. And I think there's at least a chance that if you were honest in Delaware about your purpose and you said, look, I made decision A because I wanted to benefit my employees, even though it had no chance of helping us in the short term or the long term, I think there's at least a risk of losing that lawsuit, and just that risk may cause risk-averse lawyers, which were notoriously risk-averse, and risk-averse business people to focus more on shareholders and benefit corporations. It at least makes this debate that we've been having for nearly 100 years, it makes it clear the purpose for business corporations that are benefit corporations is a holistic, multi-stakeholder focus, and you don't have to even prioritize shareholders. And actually, I don't know if I read the latest draft of the Minnesota bill, but the Minnesota bill is actually unique in saying you cannot prioritize shareholders. You've got to consider them, but they can't be your first priority if you want to be a public benefit corporation. So, good. I hope you could see that. There has been a proliferation of legal forms over just the past 6 years, which is a very short period of time if we're looking at corporate law history. When I teach business law, I focus on 3 or 4 legal forms. I think we've got 8 up there that have come into being in the last 6 years. The first was the L3C in Vermont in 2008. I think it's now in it was in 9 states. North Carolina repealed their L3C law. L3C law, as far as I'm concerned, is dead. No one's passed a statute in about 2 years. There's been no new statutes in 2 years, which in the social enterprise time, you've seen 2 statutes pass just in the past week. 2 years is a long time without a statute. There are about 1,000 L3Cs across all 9 states. The benefit corporation form is the next form, and we've seen a lot of variations of the benefit corporation statute. I've been doing some research with Kate Cooney at Yale and a couple PhD students gathering data on how many benefit corporations or public benefit corporations are out there. We've been able to identify about 400 entities over the course of 4 years, because the first statute was formed in Maryland in 2010 for benefit corporations. So over the course of 4 years, maybe 400 entities. I'll give it 500 because some of these states don't even know what benefit corporations are. We've had to go to 4 different levels. Maybe they haven't done a great job tracking them. But there's about 400 to 500 benefit corporations across all 23 or 24 states. Some of them are not yet effective, obviously. But like Professor Johnson said, that's one day in Delaware for any of the other entity forms. There's over 1 million entities formed just in Delaware. So benefit corporations, social enterprise may be the future, but we're not there yet. It's still a very small number of entities. So we have L3Cs, benefit corporations, benefit LLCs are available in both Maryland and Oregon. We have FPCs, flexible purpose corporations in California, social purpose corporations in Washington. We have public benefit corporations in Colorado and Delaware. The law in Minnesota is called public benefit corporation, but the individual entities are called general benefit corporation and specific benefit corporation. So there'll be a quiz later, but there are 8 forms. I'm short on time and I want to leave some time for questions. The 2 main, benefit corporation really is the future right now, or it's the one that's getting the most attention out of all those forms. And there's 2 main frameworks. There's the model, which B-Lab has been working on, and then Delaware went its own way in creating the public benefit corporation law. And they're different in some ways. I have an article that's coming out. It's on SSRN, will be in the Harvard Business Law Review that delves into this. But basically, Delaware allows much more private ordering. You only have to file a benefit corporation report every 2 years in Delaware instead of every year. You don't have to post it in your website or with the Secretary of State with Delaware. You do with the model. You have to have a specific purpose in Delaware, but you do not in the model. You do not have to have a third-party standard if you don't want in Delaware. So they give a lot of flexibility, but they provide a little bit more guidance to directors by having that specific purpose. They still require in Delaware you to have a general purpose, but you also have to have a specific purpose that gives a little bit more in terms of accountability and specificity. And then finally, there's been a lot of talk about benefit corporations acting as a brand. I would say I would caution there because the statute does not have much teeth. Most of the statutes, Minnesota does more than some, but there's not as much enforcement. I've read a lot of these benefit reports that you hear about. Oh, this is the transparency. Look at the benefit reports. They read like promotional pamphlets. There's really no uniformity. They're cherry picking statistics. One of them said, we had 3 employees running a local 5K. I mean, that's great, but it's not very helpful to the investor who really wants to know what sort of impact you're having. And then on the enforcement end, there's no real oversight. You have to have a third-party standard, but you can choose any third-party standard as long as it's transparent and independent. And there's a lot of variety in those third-party standards, and you don't have to get a particular score. I've seen people who've used B-Lab score, and B-Lab likes you to get an 80 out of 200 to be certified. I've seen people who scored a 26 They're a benefit corporation. They said, well, we're a young company, we're trying to improve, et cetera, but they're still a benefit corporation. B-Lab, to their credit, has a more rigorous metrics that you have to go through, but that's really the private market requiring that. You don't have to be certified. And then finally, our time here is short. I would encourage you to get on Social Science Research Network. I know the professors up here have articles there, as do I. I posted a social enterprise law bibliography before I came here, which I limited it to my field because that's what I know the most about. It's law professors mostly, but some practitioners and their articles that are available. You can connect with me on Twitter or email, and then there's a social enterprise law blog that some professors and practitioners write on, and then more generally about business law, the Business Law Professor blog, which I also contribute to if you want to stay a part of the conversation. So thank you very much.
Okay, ladies and gentlemen, now we do have some time for a couple of questions. There are two of us with mics. Just raise your hand if you've got a question for any of our panelists. Just identify yourself and the person to whom or the people to whom you want to direct your question. That would be great. We're given instructions by our AV people not to give up the mic. So that's why I'll be standing next to the person who's speaking.
I won't touch it, I promise. I just have a question, I'm assuming so, but is the income of a B Corp, or I'm sorry, rather the benefit corporation, taxed the same as it would be a regular corporation?
Yes. Well, I can speak to that. So the answer is yes. There are no tax benefits currently from the federal or state level. There have been some cities that have started to give very small tax benefits. Philadelphia has a tax credit to certified B Corps, not the benefit corporation form, but if you get certified. San Francisco has given some preference. You get extra points with government contracts if you're a California benefit corporation. But those are the only two. There's some others that are in process in my state, Tennessee. We're talking about some incentive for social businesses, but it's pretty limited.
My name is Carly Katiza-Wattoon. I'm a former student of Mike and John. Glad to see you guys. I am just curious, as far as moving forward with the legislation and as more states approve legislation going forward for B corporations, is the regulation something that we will see, more of a standardized third-party, something like B-Lab certification or anything like that? And I don't know who wants to take it from here.
Yeah, I can talk about that. Yeah, I think right now the statute with respect to the standard that's used, it sort of lays out requirements that need to be met. It needs to be a comprehensive standard, so you probably couldn't just go and use, for example, whatever standard they use to certify organic products. You know, it has to be something that looks at the whole business. There are a number of options, but the way the statute was drafted was really sort of this free market concept, allowing the business to choose the standard that they want to use for themselves, so long as it meets the sort of baseline of the statutory requirements. You know, it's comprehensive, it's independent, it's credible. And I think part of the what's going to drive that is how do the shareholders and the directors react to it. So they're the ones who, if the company, you know, if they choose a standard that's not a good standard, there's going to be pushback, I would imagine, from the shareholders. So it's really meant to be sort of more market-driven, giving the entrepreneurs the freedom to choose the standard they think works for them.
I think for the Minnesota-specific benefit corporation, I don't think there is a third-party standard certification. It's the general benefit corporation only.
My name's Debbie. Excuse me. I'm a student here, third year. This is primarily for Ms. Babson, but for any of you. I'm wondering, with your involvement with benefit corporations, have you seen some of the things that Professor Johnson was talking about, how it's been worked out in the boardroom, how directors are balancing these things, and even perhaps disgruntled shareholders who want to see more or less? I wonder if you have any insight.
Yeah, so it's pretty new, and as you heard, there's really, only a few hundred companies that have done this so far. I have been lucky in that I've gotten to work with a number of them. Usually when a state passes the legislation, there will be a bunch of companies that show up because they want to be the first one to incorporate under the statute on that day. So I've helped out a number of companies and also advised companies that were thinking of making the switch. So for example, Plum Organics was a certified B-corp. They are one of the fastest growing companies that makes baby food in the U.S. And they were also one of the companies that switched to become a benefit corporation when Delaware passed the legislation. And before they made that switch, Plum is actually a wholly owned subsidiary of Campbell's Soup. We had a number of calls with people at Campbell's to talk to them about what does this mean going forward for this company. How are they going to consider the various interests that they're required to consider? Because one of the main differences of a benefit corporation versus a corporation, for example, in a state that has a constituency statute, is that they're required affirmatively to consider various stakeholder interests. So, that's really how it's come up. To my knowledge, there have been no lawsuits yet from shareholders, so I think those waters are sort of untested. One of the things that is built into the model statute is that there won't be monetary damages. So I would imagine a lawsuit that would be brought would be for injunctive relief. Really a shareholder saying, you said, you were going to treat the environment well, and now you are doing X, Y, or Z that we don't think is within the general public benefit. So I think that those are the types of suits that you'll see. I think, Lyman was correct in that there are things to consider. And when we're advising clients and sort of talking to them about, well, what does this mean? Definitely it involves advising directors on the change in the duties and sort of how do you document that? What do you put in your minutes? Even when just simple things as a corporate attorney, when you're drafting a consent to get, to approve something, there's pretty standard language that, it's a form document almost, so you would put in the recitals. You change that a little bit to say, you're considering this to be in the best interest of all these various stakeholders, not just the shareholders. So it definitely, I think, will come into play more, and it's going to be one of the things that I try to do, I think B-Lab tries to do, as states pass this legislation, all the lawyers that are involved in those states, is to really advise attorneys so that they're able to understand what changes the legislation brings and sort of how do they advise their clients to be, complying with it, to be filing their annual benefit reports. To Haskell's point, making sure that the reports meet the, transparency requirements and they include the proper descriptions that they're supposed to, so that they're useful to the shareholders and the people who are relying on them.
One thing, most of the 400 or 500 benefit corporations that have been formed, to our knowledge, don't have minority shareholders. Most of them are very small, wholly owned. Even Patagonia, which is the largest, or one of the largest at least, are they the largest? They're at least the flagship. They're wholly owned by Yvon Chouinard and his family, right? So a lot of these conflicts haven't come up yet because there are probably some minority investors out there for sure, but the vast majority of the few are all in just a few hands, and they're the ones who decided to be this type of corporation in the first place. So,
Yeah, I think that's true, but I think the hope is that equity investors will go in as minority investors, and I would caution people that whatever these benefit corporation statutes may say, there's still a law against fraud, and you are selling securities, and so there's more than just the remedies that might be available under a benefit corporation statute.
We have time for one more question.
Hi, I'm William Bankston, and I think my question is sort of a follow-up to the previous question, but I'm really trying to think through the business value of being a benefit corporation, and I'm wondering if there are any studies on the existing benefit corporations or any projections about what the business benefits might be, or even your thoughts, and specifically to the investment community. And if the demographics of the investment community become more altruistic and they want to do good as investors, then I would expect that potentially the benefit corporations could be valued at a higher scale than other types of corporations. So I'd be interested in your thoughts on that.
Well, the B school people can speak to that. I mean, I certainly agree. I think that is the hope, and I think that's going to be the test. What happens in the market? I mean, these things may have enormous cachet for investors that really do want an economic return, but they're not maximizers. They really want to build a business. So I think that's the hope, and that's why I think how that business model evolves is going to be far more important than some of these legal issues, but I think it's absolutely critical. I don't know of any studies as to whether investors do put their money where their mouth is, but I think that's what lies ahead as to whether they really do.
I think it's been said these are very early days and there's simply no data, but one of my concerns is, going back to one of the early points, is giving a different moral status to these corporations depending on how they've been incorporated seems to be a mistake. If we set up saying that corporations are less good than benefit corporations, which are less good than nonprofits, there are many bad nonprofits and there are many very good for-profits. So it seems to me the third-party comprehensive assessment of the goodness for the shareholder seems to be a much more sensible way of assessing a business than simply looking at the articles of incorporation.
Just one point to the studies. JP Morgan, they have a social finance library on their website, and some, at least social finance investment bankers that have done some stuff in connection with Rockefeller. So that may be useful to you, kind of surveying their clients and their appetite for impact investing. So that may be useful to you. I think B-Lab has done some things, mostly, if I'm not mistaken, around the certification process to, they have deals with Salesforce.com and Quicken, and they've even talked to a few business schools about tuition remission deals for students who go and work for certified B-corp. So there's starting to be some benefits at the fringes, but it's still early.
I serve as the board chair of a small manufacturing company here in the Twin Cities. Actually, the CEO of the company's here, and we've actually had discussions over this. And actually, I'm trying to think about, as I'm listening to this question of Benefit Corp, would we ever want to sign up? And obviously, I see the legal safety net that this can do it. But I will have to tell you that this company that I'm the board chair, it has a rich, profound understanding of purpose. And actually, I can't quite see how the Benefit Corp is actually going to help us have anything richer, to be quite frank. But I guess it'd be a pity, I don't know if it's a pity, maybe it's just a reality one has to face, is that in this highly litigious society that we find ourselves in, does the Benefit Corp help us to protect us? Which actually is somewhat of an indictment on the kind of culture that we're finding ourselves in, that we have to find this kind of protection to go along with it. So I'm actually puzzled. Actually, I'm going to have a nice conversation with this CEO after this meeting about whether he sees a benefit for the Benefit Corp in a company actually that has a very rich social purpose already. It's not signing up for it. It already has it. And it's a strange, I guess it would be a strange reality that we have to sign up for these things simply for legal protection. But maybe it's the reality we're facing right now that we simply have to go in that direction.
Well, I think that we haven't answered all the questions, but we've teed them up. It's exciting to be at the precipice today, especially here in Minnesota, of this new development. And hopefully we've all learned a little bit about what kinds of things to be watching for over the next couple of years as these new forms of business organization unfold themselves. I'm going to ask you in a minute to join me in thanking our 5 panelists, but first I have to give you some instructions. We have a reception for all of you in which we can continue to discuss these things. But to get to that reception, you have to go to the second, or the easiest way is to go to the second floor where our Skyway system is accessed. You can take the stairs or you can take the elevators. Walk along that Skyway, cross one street, keep walking in the only direction you're allowed to walk until you reach another Skyway. You're going to go through Schultz Hall over 11th Street, then you're going to go into Terrence Murphy Hall over 10th Street into Opus Hall. There are going to be students directing you and there's signage directing you the entire way. When you can no longer walk in that direction at all, you're going to turn left and there will be food and refreshment waiting for you. Those of you who are going to join us for dinner afterwards have a real treat in store as we learn how to cure poverty. And those of you who are not, please do join us at least for some refreshments to continue this discussion for a half an hour. And please join me now in thanking our 5 panelists for a wonderful discussion.